call this meeting to order. Welcome to meeting number 47 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to Standing Order 108 sub 2 and the motion adopted on January 30th, 2023, the committee is beginning its study on extradition law reform. Today's meeting is taking place in hybrid format pursuant to the House Order of June 23rd, 2022. Members are attending in person in the room and are remotely using the Zoom application. I'd like to take a few moments for the benefits of the witnesses and members. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic and please mute yourself when you're not speaking. Interpretation for those on Zoom, you have the choice at the bottom of your screen of either floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed to the chair, myself. For members in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raise hand function. The clerk and I will manage the speaking order as best as we can, and we appreciate your patience and understanding in this regards. Before we begin, the technical difficulties we experienced the last meeting will have minimal repercussions on our agenda that I wish to manage in the following way. The first, the officials from the Department of Justice with us last week agreed to come back to complete their appearances in front of committee on Wednesday, February 8th. They will be with us at the second hour of the meeting. Also, you may have realized that today's notice of meeting that we're able to welcome again all of our last Wednesday second panel as they will appear today on the second hour at this meeting. I will also, just for the benefit of the witnesses members, I have cue cards, so when you have 30 seconds remaining, I will just raise this yellow card, and when you're out of time, I'll raise the red card, and I just ask that you end it so I don't have to interrupt you in your speech. Finally, we'll hear witnesses on our extradition study on Monday, February 13th. For the first hour and second hour, we'll be drafting instructions for our analysts. February 15th, we will begin the study on the bail system with the Ministers of Justice on the first hour. And for the second hour, we'll have officials with us for more questions. So without further delay, let me welcome our witnesses today, Mr. Matthew Behrens and Rania Tafali, and also from the World Sikh Organization of Canada by video conference, Balpreet Singh, legal counsel. So each of you will have 5 minutes for your opening statements, followed by questions from the rest of the members. So I'll begin by you.
Monsieur le Président.
Chair, if I may. Yes. Before we begin, could you confirm whether the audio tests have been carried out with the witnesses as required and whether the results are good?
Monsieur Fortin, they were carried out, and I've been confirmed already prior that they were effective and positive.
Merci, Monsieur le Président.
Thank you, Mr. Chair.
So, Mr. Behrens, 5 minutes for you.
My name is Matthew Behrens. I represent the group Women Who Choose to Live, which works with women who are criminalized and punished for trying to survive male violence. And I've worked on extradition cases for over 20 years, largely with the families and those who have been victimized by a process which is fundamentally flawed and violates the Charter of Rights and Freedoms on many levels. Today, I'm very honored to be here with Rania because we're here to talk about the human face of extradition and the consequences of this fundamentally flawed Extradition Act. This act has been used as a bludgeon to batter abused women, as in the cases of MM and KT. It has led to the potential for an actual torture of Canadian citizens, as in the Boily case. Mr. Boily was recently awarded $500,000 for the minister's complicity in his torture in an extradition case to Mexico. And it's also been a backdoor to forcibly remove people who are in need of protection to states where they had fled from persecution. Now, I'm happy to address broader issues related to the case, but I'd specifically like to tell you the story of one of the most significant extradition cases in the last 20 years. This is Michelle Messina. She can't be here today because she took her life at the age of 58 in a Quebec prison in November of 2019 after having spent 9 years fighting extradition. Michelle is not here because she lost her life in that prison. She took her life because she was so afraid of being extradited back to Georgia, where she knew she would not get a fair trial, for the charges of rescuing her children from clear signs of abuse from a very abusive man. In 2010, she rescued her 3 dual citizen children from Georgia and brought them here for safety. All the children are now adults. Over a decade ago, they were sleeping in an abandoned garage to escape their father's abuse. Now they've been orphaned because Canada chose to decide that it would criminalize Michelle in the same way the state of Georgia had as well. Her initial extradition was quashed in the Quebec Superior Court. On appeal, it was reinstated, and then we went up to the Supreme Court, where Michelle lost in a 4-3 decision, which the dissenting judges actually said was Kafkaesque. So we initiated a campaign for reconsideration. There was a new government that came in 2015, and Jody Wilson-Raybould actually brought in a reconsideration, but after 7 months, she signed what turned out to be the death writ for Michelle. Her reasons, in the minister's reasons, were infused with a complete lack of knowledge about the consequences and dynamics of violence against women. She asked questions in these reasons, such as, why didn't Michelle report to the police? How many times have survivors been asked that ridiculous question? In the end, Wilson-Raybould said that far from saving these children, what had happened was she had taken away the abusive father's rights to visit them. That was the conclusion of the Justice Minister, and what that does is tells us where the real fault lines are with respect to gender-based violence and the Extradition Act. Justice Rosalie Abella wrote the dissenting opinion in that Supreme Court decision, and she pointed out that the defense of rescuing children to protect them from imminent harm does not exist in Georgia, and the mother will not be able to raise the defense she would have been able to raise had she been prosecuted in Canada. This contradiction violates a cornerstone of extradition law, the double criminality requirement that the Supreme Court acknowledges is a process that ensures that Canada is, quote, not embarrassed by an obligation to extradite a person who would not, according to its own standards, be guilty of acts deserving of punishment. And I think part of the problem that we're facing here is we are dealing with government departments, and especially the so-called International Assistance Group, which works on the extradition cases at the Department of Justice, that has failed to enter the 21st century when it comes to gender-based analysis. It was mandated to do so in 2010. In 2021, the supplementary mandate letters to the ministers specifically spoke about something called Gender-Based Analysis Plus. And Gender-Based Analysis Plus would, quote, involve critical consideration of the historical, social, and political contexts and the systems of power, privilege, discrimination, and oppression that create inequities, as well as applying a meaningful approach to address them. And so if that had been meaningfully applied in Michelle's case, she might be here today to testify about extradition instead of being in a grave that her children can only visit. Now, it's critical, I think, that when we're looking at extradition, we recognize what Gender-Based Analysis Plus is about, because as you're probably familiar with that wonderful quote from Anatole France, where he said, the law in its majestic equality forbids both the rich and the poor from sleeping under bridges, from stealing loaves of bread, and begging in the streets.
Thank you, Mr. Behrens. Unfortunately, your time's run out. You're going to have to flush it out of the questions that may arise.
I'm sorry, my 5 minutes is up?
Yes. Yeah. Next, we'll go over to Ms. Tafali. If you have 5 minutes.
Thank you for inviting me to appear as a witness regarding your study of extradition law reform. As you may know, my spouse Hassan Diab was extradited to France in 2014. I have brief remarks based on our experiences. While there is concern in our legal system about the issue of wrongful convictions, in my experience, there is no such concern about wrongful extraditions. The current law is premised on the assumption that the extradited person would receive a fair trial in the requesting state and that extradition is not a trial. However, extradition to a foreign country is not a mere inconvenience. Rather, it is generally a horrific experience. In Hassan's case, he was extradited to France, where he spent over 3 years without trial, confined to a small cell in which he did not see or interact with anyone for 20 to 22 hours per day. He rarely received visitors, as we would only travel a couple of times per year given the cost. As a result, he rarely saw his children and family. He also faced a legal system that he was not familiar with, while at the same time he was isolated, deprived of meaningful social interactions, and in a precarious mental state. In extradition, the presumption of innocence is turned upside down. First, the record of the case, which is a document submitted by the requesting state, is held to be presumptively reliable, and the burden is on the person sought to demonstrate that the evidence is manifestly unreliable. The threshold is so extremely high that it is unattainable, no matter how flimsy the evidence is. Second, the person sought is not entitled to disclosure of the evidence. Third, the person sought has no automatic right to call evidence. In Hassan's case, the key evidence, which the Crown attorneys refer to as the smoking gun, is handwriting analysis based on just 5 words written in block letters. 2 French handwriting analysis experts had compared what they thought to be Hassan's handwriting from late 1980s and 1990s with 5 words on the hotel card written by the suspect in 1980. Neither of the French handwriting analysis experts had to testify or be cross-examined. In fact, the law does not allow the defense to cross-examine them. Rather, their opinion, even though handwriting analysis is commonly believed to be junk science, was considered presumptively reliable. The burden was on Hassan to prove that these 2 reports were utter nonsense and that they were based on many documents that were not even written by Hassan, but by someone else. It is a fundamental principle of justice that the state should bear the burden of showing that its evidence is reliable. I find that shifting the burden of proof and limiting the ability of the person sought to defend himself or herself and denying them disclosure of evidence is a travesty of justice. The current extradition law is justified by the need for expediency. However, expediency should not trump fairness. In addition, extraditions in Canada are not expeditious at all. They last years. The other issue that is often used to defend the current extradition law is the claim of reciprocity and the need to honor Canada's international obligations. However, having an extradition law that is more just and fairer does not undermine Canada's international obligations and the rule of law. While some of those thought for extradition are guilty, the same can be said for those charged with a crime in Canada. However, this does not prevent us in Canada from demanding reliable evidence before the accused stand trial in Canada. We should have the same care and concern regarding extradition so that innocent people don't suffer needlessly. In reforming the extradition law, I believe that 4 issues are critical. The evidence submitted by the requesting state should not be presumed reliable. There should be full disclosure of relevant evidence, of all relevant evidence. The person sought should be allowed as of right to call evidence, and extradition judges should be permitted to consider issues of fairness. Thank you.
Thank you, Ms. Tavali. You actually had a few more seconds, but you were in time. We'll next go to Balpreet Singh from the World Sikh Organization. You have 5 minutes.
Thank you. So the issue that we're talking about today touches on both of our mandates, which are to advocate on behalf of Canadian Sikhs as well as to protect human rights for all individuals. In short, Canada's extradition process is deeply flawed and needs urgent reform. At the outset, I'd like to say that our organization supports and endorses the Halifax Colloquium's proposals for law reform. Specifically, it's our position that human rights considerations must be at the core during extradition processes. While charter protections apply only to Canada and not to foreign states, where there's a causal connection between the abuse of human rights of an accused in a foreign country and Canada's decision to extradite, charter protections must be enforced. While in the current process, human rights are contemplated, those considerations are tempered by considerations of reasonableness and deference to the court, by the court to the minister in matters of foreign affairs and international cooperation. This is based on the court's assumption that Canada does not enter extradition treaties with countries not worthy of its trust. For this reason, the Minister of Justice's decision to extradite is largely a political one. We believe that that leaves the extradition process open to misuse and abuse. Specifically, with regards to the concerns of the Sikh community, Canada's extradition treaty with India is highly problematic. That treaty was entered into in 1987, and according to Joe Clark, who was then the Foreign Affairs Minister, the key consideration between the negotiating countries was India's desire to extradite Canada-based quote-unquote Sikh extremists. What makes this treaty especially problematic and surprising is that while Canada has ratified and the UN Convention Against Torture,
I'm just going to ask you,
rights,
Mr.
both which prohibit
Mr. Singh, if you can just go back
Yes.
30 seconds. There was a technical issue with your sound, so which probably also didn't get interpreted. So maybe just I'll give you extra time for the 30 seconds that might have been lost.
Do you know whereabouts? What the last thing was that was heard?
You had started with the 1987 extradition treaty with Joe Clark.
Got it. So, Foreign Affairs Minister Joe Clark at that time had admitted that the key negotiating issue behind the treaty was the Indian desire to extradite quote-unquote Sikh extremists. What makes this treaty particularly problematic and surprising is that Canada has ratified and is party to the UN Convention Against Torture, as well as the International Covenant on Civil and Political Rights, both which prohibit removal to the danger of torture. India hasn't ratified the Convention Against Torture and has long neglected its obligations and reporting duties under the ICCPR. So India is not bound by the Convention Against Torture's prohibitions against torture and is not subject to monitoring and review by the UN Committee Against Torture. So as a result, the Asian Human Rights Commission says, quote, torture is practiced as a routine and accepted as a means for investigation. Most police officers and other law enforcement officers consider torture as an essential investigative tool. There's a lot of evidence to suggest that torture is routine and very common in India. And this is common knowledge among Sikhs that Sikh political activists taken into custody in India are brutally tortured as a matter of routine. So given the context within which the India-Canada Treaty was negotiated, specifically with a desire to target members of the Sikh community, and the fact that during almost every bilateral meeting between Canada and India for well over a decade, Indian officials have made unsubstantiated allegations of extremist activity in the Canadian Sikh community, there's a real fear that Sikhs in Canada may be extradited to India and face false charges and torture. On several occasions over the past few years, India has in fact presented Canada with lists of Sikhs in Canada it wants to have extradited. What India deems as extremism is in fact Sikh advocacy on various issues India finds objectionable, and all are protected under Canada's right to freedom of speech. But India has nevertheless repeatedly demanded that Canada crack down on Sikh activists in the country. Specifically now, in the light of Canada's launched Indo-Pacific strategy, India High Commissioner has said that in order to improve ties, Canada must crack down on segments of the Sikh community in Canada that are offering support and money to secessionists who want to separate Punjab from India. There's no evidence to substantiate that allegation, but we are afraid that Canada may be pressured by India to extradite Sikh activists in return for closer ties with the country. And it wouldn't be the first time that Canada's buckled to Indian political pressure. In the past, where visas to members of Indian security forces have been denied due to suspected involvement in human rights violations, Indian protests have in fact resulted in those visas being issued. And it's also felt that in the aftermath of the Prime Minister's 2018 trip to India, the term Sikh (Khalistan) extremism was added to the Public Safety Report on Terror at the insistence of the Indian government. So it's our firm position that if extradition is a political consideration that does not have human rights as a central consideration, that's not right. So diplomatic assurances are also not a solution because they're unenforceable, and where there's in fact a violation, both countries have very little incentive to bring that breach to light. So we submit that Canada should not have an extradition treaty with a country that has human rights abuses or that have failed to ratify human rights treaties. And as such, the India-Canada extradition treaty does not meet the necessary standards. That's my submissions.
Thank you, Mr. Singh. We'll now go to our first round of questions, and we'll begin by Mr. Brock for 6 minutes.
I think it's me.
I'm in the second round.
In a second, sorry.
Yes, I wish I
Mr.
was.
Caputo, you're
Thank you.
so
I wish I
green.
was nearly as handsome as Mr. Brock, but you'll have to
Brock,
put up with me, Mr. Chair.
Maybe, yeah, yes, he does.
Mr. Naqvi, no jokes about hairlines, especially from you. Thank you very much. Mr. Behrens, you didn't get done your time speaking. I'm prepared to just cede the floor to you if you want to finish up your comments, please.
That's very wonderful of you. Thank you. Let me just get back to where where I left off was talking about the gender-based plus analysis and why we need that. So what I would like the committee to consider is, in addition to the Halifax proposals, which you've either heard about or will be hearing about tonight with Professor Curry, that you look at the creation of a body that is independent of the International Assistance Group. Because right now, what we have is a foreign jurisdiction makes a request to the Minister of Justice, which goes to the International Assistance Group, which makes a recommendation. Then we go to a judicial review, and then there are final submissions which go back to the people who initiated the process. So we need some kind of independent oversight in there. And as part of that independent oversight, we need to have a real, transparent, and intelligible and justificable analysis in cases that especially involve women and children who are fleeing violence, racialized individuals who would clearly face discrimination if they were sent back, even to a jurisdiction like the United States. George Floyd, Breonna Taylor, Tyree Nichols. That's all you need to know. But what the problem is that in the Extradition Act itself, and this has been confirmed by the Supreme Court, ultimately the surrender decision is not a legal one. It's a political one. And so basically what the Minister of Justice is tasked with is deciding whether or not he's going to piss off the United States if they do not receive the requested individual, or piss off the government of France. And that's the problem, where we have they've got this massive discretionary authority where they can essentially say your charter rights are secondary to our concerns about state-to-state relations. So that, I think, is something that we really need to look at. The other thing that's a real concern is that often when we do present evidence to the Minister of Justice about the risk of torture, the risk of other human rights abuses, they come back at us and say, well, if you're going to Chicago, which has one of the highest rates of police torture of black detainees, there's always a remedy. You can make a complaint to Amnesty International, or you can go to a federal court. But redress for harm done is not protection of fundamental human rights. It's an after-the-fact remedy. But you should be entitled to human rights protection in the first instance. It shouldn't be payment of damages after the harm has been inflicted. The other thing I just wanted to share, and I do appreciate not only your beautiful hairline, but also your sharing your time with me, is that in the case, Justice Abella said, at the end of the day, there's little demonstrable harm to the integrity of our extradition process in finding it to be unjust or oppressive to extradite the mother of a young children she rescued at their request from their abusive father. So she recognized that at the Supreme Court, as did two other justices, and the fact that it was split right down the middle by gender is very interesting as well. If I do have about 30 seconds, one other thing I think really needs to be on the agenda here is the way in which the Extradition Act intersects with the Immigration and Refugee Protection Act. Because we have seen in a number of instances, especially when it comes to Roma refugees coming from European countries such as Hungary or the Czech Republic, whereby after years of being here as a protected person as Roma people, suddenly there is an extradition request. And based on the low standards, they then face losing their refugee protection. And we have a number of cases where the Minister of Justice has gone to the Minister of Immigration and asked for a new opinion about the risk allegedly that may befall that person if they are sent back to a state where they fled from persecution in the first place.
Thank you. Ms. Tafani, did I pronounce that?
Yes.
Or Tafali, sorry, Tafali?
Yes.
Okay, I apologize if I don't pronounce your name correctly. You brought up disclosure, and this is really a cornerstone of Canadian criminal law. My question is this. Is somebody who is going to be extradited, are they entitled to the disclosure that is in the possession of the Canadian government?
I mean, this issue has been debated in Hassan's case. The Department of Justice currently says that no, they are not entitled for disclosure of evidence that is with Canada. For example, there was a fingerprint analysis that was done in Hassan's case, comparing his fingerprints to fingerprints that found on documents that was handled by the suspect, and these fingerprints were negative. But Hassan were not told about it, nor was his lawyer or the extradition judge during the committal phase of the extradition hearing. And the rationale of the Department of Justice is that Hassan is not entitled to know such evidence because the extradition law allows this.
Now, was that fingerprint analysis possessed by the Department of Justice at the time?
Yes, it was done in Canada. So it was the Department of Justice asked France to send the material that they had so that they do the fingerprints in Canada. So the RCMP did the fingerprints here. So yes, the Department of Justice had this evidence.
Oh, that's interesting. So just
Thank
so I'm
you.
clear. Oh, sorry.
Thank you, Mr. Caputo. Next, we'll go to Ms. Dillon for 6 minutes.
Thank you, Mr. Chair, and thank you to our witnesses for being here. I'd like to maybe ask a general question and start with Mr. Behrens, Ms. Rania, and Mr. Singh. Can you please comment on the experience of racialized Canadians with the Extradition Act? We could start with you, Mr. Behrens.
I'd be happy to do that. I'll give you an example of one Canadian citizen who was sought in a Chicago cold case in 1969. It's called the Freeman case. This is an African-American man who came to Canada because his life was at great risk, and he lived here peaceably for 35 years. The extradition request was based on the officer who was allegedly injured in the incident being the investigating officer. When the so-called record of the case was put before an Ontario Superior Court, I'm going to quote the judge here, it was so full of holes and inaccuracies. There was one account by this police officer in which he said, oh, there were 7 shots fired. There was another account in the same record of the case, which is presumed to be reliable, of 13 shots. The judge says, factually, there is a significant difference between the two accounts. You don't have to be a mathematician to know that 7 is different from 13. 12 is about 13, or 14 is about 13, but not 7. What it means is the ultimate result may be another matter quite altogether. Suppose both were included in the record of the case. What's the extradition judge going to do about it? Very interesting. That was his only it's very interesting. They upheld that extradition, and Mr. Freeman spent years in custody here in Canada. In the end, he was able to settle with an agreement and did 30 days in the Cook County Jail, but certainly at fear for his life, because anyone who has studied Chicago knows that the Chicago police have a very well-documented record of torture of African Americans.
Thank you so much. Ms. Rania, please.
Okay, thank you.
Thank you.
So there is this assumption that the justice system in all countries that have extradition treaties with Canada is fair, and it is fair for all of the people, regardless of their gender or race, ethnicity, and so on. However, this is often not the case. I mean, if we look at Muslims in particular, we know that in many countries they are treated unfairly under the law, that there are certain rules of evidence that are eliminated when we have Muslims who are accused. And this is the case in France. Human Rights Watch, there are other organizations that have documented France's use of torture, France's use of secret intelligence that cannot be tested in court, that is rejected in Canada, for example. It is used in order to convict people. And I find it, I mean, I have been working on this case for so many of my life. I think maybe all of my 30 spent on Hassan's case. And when talking to people, I find that it is hard to convince them that a country like France is unfair to some segments of people. I mean, I don't know why. I mean, if we look at the US, we see there is racial discrimination. If we look at the history of Canada, we see that there has been discrimination against different people, Francophones, against, for example, indigenous people. So like this assumption that, the justice system is fair to everyone, I don't think it is based on solid evidence.
Thank you, Ms. Rania. And Mr. Singh, I think our time is going to run out, so please take the rest of it to give your statement. Thank you.
So I will just say that it's rather disturbing for my community when India-Canada relations are sometimes dominated by the question of what Sikhs in Canada are doing or not doing, and the potential of Sikhs being extradited to a country that routinely tortures based on a desire to improve ties. That's very, very scary for our community, and that's something that the current system allows, and it really shouldn't.
And what would you like to see improved in the current system?
I think overall, the Halifax Colloquium's submissions on reform to the system are very persuasive. So I would direct you to them. And I think your next witnesses and further sessions will be talking more about that. But specifically, human rights has to be at the core of things. And countries that have not signed onto human rights treaties or have records of human rights abuses, Canada should not be extraditing people to those countries.
I thank you so much.
Thank you, Ms. Dillon. We'll next go over to Monsieur Fortin for 6 minutes.
Merci.
Thank you, Mr. Chair. And thank you to our three witnesses with us here today. I will begin with Mr. Behrens, if I may. I understand from the testimony heard here overall, and I think we're all pretty much in agreement, that we should not Testing.
Volume on.
Testing once again. Do you hear me now? Good. Mr. Behrens, good. So let me begin again, Mr. Chair. I imagine that we can just hold the clock on that. Thank you. So I was just thanking you for your presence here today, and I was saying, Mr. Behrens, that I would begin with a question to you. So what you have to tell us today is that Canada should not have treaty agreements with countries that carry out torture or do not respect human rights. I think that's something we can take for granted. I don't wish to speak for my colleagues, but I think we would all tend to agree with that. What I find relevant, though, is the following. What are the ways we could go forward? In the current system, under the current process, in principle at least, Canada will not extradite, will not surrender someone to a country that does not respect human rights. I think that's already the way the process works. Have there been cases where this has occurred nevertheless? Legal errors, I'm sure, and you could surely tell us more about that. But what do you think should be changed in the current extradition process in the legislation to ensure that that not take place again?
Thank you for your question. We recently had a federal court case in which the judge found that the extradition gave rise to a substantial risk of torture that had not been assessed by the minister, despite the information which had been put forward to show clear risk of torture. This was with the government of Mexico. According to Suresh, the Suresh decision, his extradition was therefore contrary to Section 7 of the Charter unless there were countervailing exceptional circumstances. So again, I think in addition to the Halifax proposals, which you'll be hearing about this evening, we have to look at this law up and down in terms of how it complies with international fair trial standards. And right now, there's so much discretion with respect to the minister's role here and whether or not he orders a surrender. That's just not happening. And as the Supreme Court has pointed out, ultimately, he's concerned about whether or not he's going to antagonize another nation. We saw this in the Aurora inquiry, which was also looking at Canada's complicity in torture. And at that time, we learned that the Department of External Affairs kept its human rights records on other countries secret for the specific purpose of protecting Canadian commercial transactions abroad. So we have to kind of step back from this and say, what ultimately, are we about upholding charter rights? Are we about compliance with the Convention Against Torture, or are we not? We see this consistently in the immigration system, where the risk of torture is routinely dismissed by immigration officers in attempts to engage in deportations. And we see the same thing with respect to extradition.
Donc, si je comprends bien,
So if I understand correctly, what you're suggesting is that the minister no longer have, discretionary power, that ultimately the court be making the decision as to whether an extradition should occur or not. Is that your position?
Court would be far more independent than the individual who has decided to proceed with the extradition. The minister has already made his position clear by proceeding with the extradition. So he's got a bias. He's decided that this is a case that needs to be pursued. He fights it in court, even though the court process itself is completely neutered by the Extradition Act. So we need to beef up the role of the judiciary in this process, because that's the only oversight mechanism which will ensure that the sought individual's rights are going to be upheld and respected.
merci, M. Barron.
Thank you, Mr. Behrens. Now, Ms. Tifele, is this your position as well, that the decisions should be made by the courts and no longer by the minister? Is that correct?
I agree, because in our experiences as well in other extradition cases, generally speaking, the Attorney General is not going to take a difficult decision and have, conflict with other countries. But if judges were to take this decision, we feel that, this is going to be that the Attorney General can justify this by that this is Canada applied the rule of law. This is what our judiciary have ruled, and we would abide by this.
Merci, Madame.
Thank you, Ms. Tifele. Mr. Singh, do you confirm that that is your position as well, to the effect that the decision to surrender, to extradite a person or not, should be made at the court level, such that the minister would not have much to say about it other than to deal with the request at the outset? Is that your position as well?
I think that makes a lot of sense. I would suggest that the judiciary needs to have a greater role. There needs to be the review of evidence. The presumption of innocence has to be a part of it. And if the minister is to be involved, then the standard of review of the minister's decision has to be on a higher standard. Right now, the lowest standard is used to review the minister's decisions, and that's unacceptable. And I'll just go back to your opening point. It's actually not taken for granted that countries that haven't signed, for example, the Convention Against Torture, we shouldn't be deporting there. We are, in fact, doing that. For example, the Badesha case was all about sending someone to India, which has not ratified that convention. And that's shocking to our conscience. It really shouldn't be happening.
Merci, M. Singh.
Thank you, Mr. Singh.
Thank you, Monsieur Fortin. Next, we'll go to Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair, and thank you to all three witnesses for being with us today. I'm going to ask, I think, one question of each if I can get through my 6 minutes. Mr. Behrens, in the beginning, when you talked about the gender-based problems in the extradition laws, one of the things that struck me from the beginning is the concept of double criminality and the fact that we proceed on the very narrow grounds that something would be illegal in both countries without considering that the way gender operates in those countries will be quite different, and without considering what some, I think it was the BC Court of Appeal called an alignment test. What are the consequences, the possible consequences of this double criminality, and are they quite different in the two countries? So can you say a little bit more about how that gender impacts that issue of double criminality? And you mentioned child abduction for safety, for instance.
Yeah, and in the case of MM and also in the case of KT, the ability to actually present evidence of abuse was dismissed as irrelevant to the proceedings. The judge doesn't want to hear about that because the judge's hands are tied with respect to how the Extradition Act, they says, this is not a trial. I'm just trying to look at whether or not there's a prima facie case against you. In the case of MM, we went to leading experts in Georgia, lawyers, university clinics, and got expert opinion to show that if had been charged here in Canada, she would have had the right to a full defense. She did not have that right in Georgia, and under the Extradition Act, you cannot proceed if that is the case. Unfortunately, the minister just disagreed and went ahead. I think any good judge looking at that would have said that cannot stand.
Thank you. Ms. Tafali, the question of whether someone being surrendered will be tried within a reasonable time, certainly the poster of bad surrender is your husband's case, 3 years without trial. So do you see any way that Canada could refuse surrender under the current circumstances if there's not an assurance they're ready to go to trial?
I think that, the threshold for assurance is very low. So the state would only have to say that, we are going to take this case to trial. In Hassan's case, his lawyer argued in front of the Court of Appeal that France is not ready for trial, that they are still investigating the case. And, the Minister of Justice said no, that France, charged him, it is ready for trial. And Hassan goes there, and it is for investigation. So the investigation takes for like 3 years and 2 months. And then he was released because the two investigative judges found that, the evidence supports, his innocence rather than his guilt. And that's why he returned to Canada. So under the current system, the requesting state can say, no, we are ready for trial, and that all it takes, and the Minister of Justice would believe that.
And can you tell us just briefly what's happening with your husband's case now in France?
Okay, so in France, there has been this back and forth between different investigative judges, different judges. So on bail, Hassan was ordered release, I think, 7 different times, but the Court of Appeal every time would quash it, even though it was different judges who would order his release. For his release from detention and return from Canada, the Court of Appeal kept on postponing that decision over 2 years. And eventually, a new panel of judges that came, they overturned the previous investigative judge's decision. So now France plans to proceed in a trial in April.
And so there is a risk that there might be a further request for extradition.
Yes. And I do want to mention that, if I have 30 minutes. Okay, 30 seconds, yes. That, Hassan was extradited on the basis of this handwriting, and it really, not just because I'm his spouse, but I'm still shocked that this happens based on 5 words. Imagine that, in this age, we would say we can identify a person based on handwriting analysis of 5 words. We had 5 experts from different countries who all said this is utter nonsense. And in France, 2 more experts were hired, and they said that they agree with the defense experts in Canada that this was utter nonsense. And here we are after 15 years, and we are still in this. Yeah. Okay, thank you.
Mr. Singh, I'd like to talk again about the treaties. And I think what you've highlighted in your testimony is that not only we do have a very dated extradition law and faulty extradition law, we don't have any process for reviewing the treaties, the extradition treaties, and many of them are also so quite old. So I guess my question to you is, do you think that there should be some process for reviewing the extradition treaties that we have on a periodic basis, and also then in that process whether you could check for the Convention on Torture and those kind of things?
Absolutely. So I would suggest that there needs to be a regular review of our treaties, and we need to make sure that the countries that we have these treaties with are living up to their obligations underneath the treaties. So like I said, India is a signatory to, but has not ratified the Torture Convention. But even the ICCPR, which it has ratified, it has not been meeting its obligations and not been reporting for, I think, 20 years. So even though it is that, not living up to its obligation, the review of our treaties is very important, and actually seeing whether they're living up to their human rights obligations.
Thank Sorry,
Out of
Mr.
time,
Garrison,
sorry.
you're
We'll come
out of
back.
time. Before I go to the next one, I just wanted to use my liberty as chair to ask a couple questions myself. Mr. Foley, can you tell how long it took before the trial even commenced in your case, in Mr. Diab's case, as well as if you know other similar cases that were the duration of time? I think Mr. Garrison had asked you the similar question, but I wanted to know exactly how long it took for your trial of your husband to actually commence, as well as if you know others that might have taken a long time that were extradited from Canada.
Yeah, so in Hassan's case, he was extradited in November 2014. He was in prison in France until January 2018. And all during this period, the investigative judge was still investigating the case. And in January 2018, he said that, he's not going to order a trial and that Hassan is released. So it took like 3 years and 2 months. I didn't review other cases regarding how long they have stayed, but I want to mention in Hassan's case, the case started in 2007 by a leak to a journalist. So he was under surveillance by the RCMP for a year. And then after a year, France requested his extradition. So this is from 2008 until 2014, his extradition hearing. And then from 2014 till 2018 in prison. And then from 2018 till now, the appeals in France. And this is not over. So it's going to take like 20 years or so of one's life and the life of children and other family members.
Getting against the principles of a fair and quick access to justice. Mr. Singh, my question to you is in the last 10 years, if you can recall how many extraditions have happened to India, and if so, did they go up any court challenges, or have they all been quashed? Because you had a lot of concern about the fact of India's extradition request, just trying to understand how many might have happened in the last 10 years.
So the main ones, of course, the Badesha and the Sidhu one. Now, that case was an interesting case in the sense that it was an honor killing, and the accusations and basically the proof that was being submitted, it was quite convincing. So sometimes they say, bad facts make bad law. I would suggest that the emotional considerations in that case, allowed for the extradition to India. But the fact is, any extradition to India should not be happening, like I said, based on their refusal to abide by human rights norms. And secondly, I would suggest that where prosecution could take place here in Canada, that should be our first choice as opposed to sending people somewhere else to have that done. So what's also quite concerning is the fact that India regularly and publicly talks about lists that they're submitting to Canada of Sikh activists that they want to be extradited. And that's definitely a concern. Not that any of them have been extradited, but the possibility that that could happen and Canada has the channels open to have that happen is very, very concerning.
Thank you, Mr. Singh. I'll go to our next round of questions, and we'll begin by Mr. Venpopta for 5 minutes.
Good. Thank you, Chair, and thank you to the witnesses for being here. Mr. Singh, I will start with you. Thank you for your evidence. Now, your website expresses concern that in India, state criticism and dissent are labeled extremist and anti-national, and that Indian security and intelligence agencies have been cracking down on those exercising what, frankly, here in Canada is quite lawful. Is that a serious concern? Because doesn't the double criminality test requirement prevent us from extraditing people from Canada to India on those types of charges?
So what we're seeing is concocted of charges. So India is an outlier in the fact that putting up a poster or graffiti outside of your own home, in fact, is now being cracked down. For example, people have been arrested for writing Khalistan on their walls of their own homes. That having been said, these individuals aren't necessarily charged with there are concocted charges, support of terrorism, funding of terrorism, and that's what we're seeing here. Activists who are talking about Khalistan or human rights abuses in India are being accused of funding terrorism. And the fact is, Canada's system does not allow for an in-depth examination of that evidence. Often just the accusation itself and a superficial summary of that so-called evidence would be enough to allow for an extradition if the minister wanted to do so. And given that India is saying that closer ties are dependent on Canada cracking down on Sikh activists, it makes us very nervous. I mean, the last time Canada granted visas to human rights abusers, Punjab police officers who were accused of human rights abuses and were long denied visas, was right before Prime Minister Trudeau's 2018 trip to India. 4 of them were granted visas at that time. I mean, that was clearly a political decision, and what scares us is that a political decision could happen in the future to extradite Sikh activists, and there would be nothing that we could do about it.
Good, thank you. So now, I believe that you had said that India did not ratify the UN Treaty Against Torture. If it had, would that make a difference to you?
Not just ratifying. For example, it has ratified the International Covenant on Civil and Political Rights. The fact is that for over 20 years, it's neglected its obligations and reporting requirements under the ICCPR. So just by signing it is not enough. There has to be a demonstrable adherence to those norms. I mean, what we're talking about is routine torture. I mean, I've got an article from December 2021 by Dr. N.C. Asthana, former Director General of Police from India, who writes that torture and fake encounters came to be regarded as in the national interest and rewarded with medals where people are accused of being separatists. So this is a serious problem, and just ratifying a treaty is not enough. You have to demonstrate that you're following those obligations.
Do you see any way clear at all for Canada to have an extradition treaty with India?
No, of course. Any country that demonstrates that it is adhering to human rights norms should be something that we can consider as a country that we can enter into these things with. Now, of course, what we're submitting is not just about India. We're talking about the whole extradition process. The whole extradition process needs serious reforms. I mean, there needs to be, once again, a presumption of innocence. There needs to be greater analysis of the evidence, and there needs to be political considerations removed, and the standard of review needs to be higher. It's not just the lowest standard of review. So is it possible? Yes, but the path to get there would be incredibly long, especially for India.
So just so I'm clear, a country like India, and I'm like, we could talk hypothetically about other countries as well, would, as a bare minimum, be required to have adopted the United Nations Declaration Against Torture or some other similar international agreement. But that is not enough. It's a necessary condition, but not sufficient for us to have an extradition relationship with this country. Is that your evidence?
That's right. I would suggest that meeting the obligations underneath the treaty, for example, reporting obligations, for example, where you have the Convention Against Torture, having the Committee Against Torture, doing the reviews. I mean, what you would have is unfortunately what we feel, even if there was a ratification, there would be a bar on the UN Committee Against Torture from doing the reviews. I mean, Amnesty International is barred from operating in India because they don't want any review of their human rights record. All of this is very, very disturbing.
Sure. Time's up. Sorry, thank you very much.
Thank you, Mr. Von Popta. Next, we'll go to Mr. Naqvi for 5 minutes.
Thank you very much, Mr. Chair. And I'm going to be directing some of my questions to Ms. Tufeli. And in light of full disclosure, I just want to know that I let everybody know that I know Ms. Tufeli personally, and our children have played quite often together in the past. So I know the family and their circumstances quite well as well. And thank you for being here. I know this is a very difficult topic for you because what you have lived through and continue to live through due to Mr. Diab's case. I was particularly interested in the 4 recommendations you made in the end of your presentation, and I felt that you kind of ran out of time and you were going through those 4 recommendations a little quickly. Do you want to take some time and talk about those 4 recommendations, Mr. Tufeli, and explain to us why you feel that they are important and this committee should consider those recommendations in their report? Thank you.
Yes, so the first recommendation was that the requesting state should not, evidence should not be presumed reliable. Because with the current system, all the requesting state had to do is just a summary of the evidence. They don't have to disclose the evidence. So in Hassan's case, they didn't even have to provide the handwriting analysis report. They only had to say that French expert X had found or had came to this conclusion, and that is going to be presumed reliable. So this shifts the burden on the person thought to try to rebut it. So we had to have, handwriting experts from different countries, and we hired ones that worked for the FBI, for the RCMP, some who were Swiss, and all of that not only cost money and extra legal fees, and it's extremely expensive and unaffordable, but our system is based on the premise that the state should provide evidence of the reliability of its evidence rather than the other way around. So that's why, shifting the burden to the person thought is not fair. The second one is that, for a person who's going to be deprived of his or her liberty, going to prison for so many years, they should be allowed a chance to defend themselves. So there should be disclosure of relevant evidence. We're not saying that, tons of all evidence that has been collected, but at least relevant evidence. And in Hassan's case, France did not disclose many relevant evidence. So, for example, they had done analysis on the hotel card. In France, this was done in 2008. And it's different from the one that was done by the RCMP. And it showed that the fingerprint on the hotel card that was signed by the suspect is not Hassan's fingerprint. But this was suppressed from the Canadian court. Actually, the Canadian court said that no fingerprint exists on the hotel card. And we found out later, after Hassan was in France, that this was not truthful. But if we had disclosure to the relevant evidence, Hassan would have known this, and it could have made a difference in his extradition. The other point is that Hassan was not allowed to call evidence. This is common to all people facing extradition. So we had to convince the judge that the evidence that Hassan is presenting is really relevant. It could knock the case out. So the bar was very high. Hassan's lawyer had to argue for so many days in court for Hassan to be allowed to call the handwriting experts, for example. And the last one is that, was mentioned by others, that extradition judges, they are not allowed to consider issues of fairness. So in Hassan's case, the extradition judge would say things in court like, if this were in Canada, I would have done something differently. Or he would say, whether I like it or not, this is the law, and I have to abide by what the law says, even if he does not like it. And when issues about fairness was mentioned, he would say that, this is not under, my domain. This is up to the Minister of Justice. So again, I think we should empower the judges because they are more independent, and I think judges in Canada are more likely to take difficult decisions than Ministers of Justice.
Time is up. Thank you. Thank you.
Thank you, Mr. Naqvi. We will next go to Monsieur Fortin for 2.5 minutes.
Merci, Monsieur.
Thank you, Mr. Chair. At present, Mr. Faley, you're correct to say that a court hearing a case must base their decisions on the record of the case. There is no actual trial. There's a trial in a sense. The court is involved in whether or not the person shall be surrendered, but there is no trial regarding the presumed guilt of the person. So if you go back to the possibility of there being no further extraditions, decisions taken solely by the minister, but the courts would always be involved. Must I take it that your suggestion is that courts should hold full trials to decide whether the person is guilty or not? Is that what you're suggesting?
Ideally, if this is my personal decision, which I don't think it's going to happen, I think prosecution should happen in Canada. If there is going to be a trial, I think it should happen in Canada rather than Canada extraditing to other countries that there might be torture, there might be long imprisonment, the rules of evidence might be very different from here. I think for fairness and to ensure that those who are guilty are brought to justice, prosecution should happen in Canada. And with Zoom, which have been doing through the pandemic, I think this is achievable to have witnesses who don't want to travel to Canada to appear by video conference. But if this is difficult to implement, then I believe that judges should be empowered and the extradition law should be changed to allow the person thought a meaningful chance to defend themselves.
But, in cases of extradition, we take it for granted that the crime is held to have been committed in a third country and not here. So it is a crime under the legislation of that particular country. In principle, a Canadian judge couldn't or shouldn't be rendering decisions on cases that really are to be decided under the legislation of that other country. Isn't this as well a procedural justice issue, a matter of fairness? Having a judge who doesn't even know what the applicable legislation is, they would be making a decision about guilt?
Okay. Well, there are many countries in which Canada has extradition treaties with, and they don't extradite to Canada. So France, for example, does not allow its citizens to be extradited to Canada. Rather, it holds the trial in France for them. So why France can do that while Canada does not? Like France is trying to protect its citizens, right? While Canada often tries, to leave them without protection.
Thank you.
Merci.
Thank you, Mr.
Thank you.
Mr. Garrison for 2.5 minutes.
Thank you, Mr. Chair. I know we started a bit late and we're going to run into time problems with our next panel. So I'll just close by thanking the witnesses once again, and in particular Ms. Tafali, whose family has gone through enormous struggles with this. And I think that the strength of her presentation today is a testimony to the strength of the family. So thank you once again.
Thank you to the witnesses. I want to thank Ms. Tafali, Mr. Behrens, Mr. Singh for your time. We're now just going to suspend for a minute or two while we do sound checks on our next panel. Thank you. hopefully all of you on Zoom and Mr. Naveen here learned my protocol on 30-second cards, and I give a red card when your time's up, so I don't like interrupting. And just make sure you have your interpretation on the right channel, so we don't have any challenges with interpretation. For those on Zoom, it's you can pick floor English or French, and in the room you can do the exact same as well. So we'll begin by having opening statements from our witnesses for 5 minutes. I think we have, as individuals, Mr. Robert Curry, a professor of law from Schultz Law School, Dalhousie. We have Dr. Joanna Harrington, professor of law from the Faculty of Law at the University of Alberta by video conference. We have Alex Neve, senior fellow, Graduate School of Public and International Affairs here in the University of Ottawa. So thank you for returning. I think you guys were all scheduled the other day, and unfortunately, because of technical difficulties, we had to reschedule you. So thank you for your consideration in that regards. And I'll begin by Mr. Curry for 5 minutes.
Would it be okay if I ceded my spot to Mr. Neve? I think it would be better if he set things up.
I'll go with you, Mr. Neve, first for 5 minutes.
Thank you very much, Mr. Chair. Yes, we have a bit of a game plan for you. So you have just heard about Hassan Diab's labyrinth of injustice from his wife, Rania Tafali. And I want to begin by really acknowledging what a courageous and remarkable woman she is, and as I think, as many of you said in your comments, acknowledge the incredible injustices that family has been through. I, too, want to highlight key lessons from that case, which begins on October the 3rd, 1980, when 4 people were killed and 40 others injured in a terrorist bombing outside a synagogue in Paris, a harrowing crime for which there must be justice. 28 years later, on November 13th, 2008, Hassan Diab, a Canadian citizen, was arrested on a French extradition request, accused of carrying out that attack. Over the next 6 years, he went through lengthy extradition proceedings, but ultimately was extradited to France. You've heard about the debacle of the handwriting evidence in his case, which Ontario Superior Court Justice Moranger described as, quote, highly susceptible to criticism and impeachment. Nevertheless, Justice Moranger concluded that he had no choice but to order extradition, even though, in his words again, quote, the case presented by the Republic of France against Mr. Diab is a weak case. The prospects of conviction in the context of a fair trial seem unlikely. That was the outcome because the threshold for extradition is that low. Hassan Diab was imprisoned in a maximum security prison in Paris for 3 years and 2 months in solitary confinement almost the entire time. And it's worth reminding ourselves that international human rights standards recognize that prolonged solitary confinement beyond 15 days constitutes torture or cruel treatment. He was held that long because, despite French assurances that they were ready to go to trial, they clearly were not. The weak case against Dr. Diab collapsed further. Judges eventually corroborated his long-standing claim that he had been in Lebanon, writing his university exams at the time of the bombing. Finally, on January the 12th, 2018, French judges concluded there was insufficient evidence to charge him and ordered his release. He returned to Canada, but this was not over. The French prosecutor appealed. The appeal was upheld. And as you've heard, a trial against him will now take place in Paris in April. His extradition has not been sought a second time. Instead, he is being tried in absentia, which of course raises further fair trial and justice concerns. To call his experience Kafkaesque would be a dramatic understatement. Further concerns have emerged about the earlier extradition proceedings, including revelations that Canadian government lawyers did not disclose exculpatory evidence that Dr. Diab's fingerprint did not match fingerprints on record, and that government lawyers were actively advising the French government about how to strengthen its collapsing case against Dr. Diab. In a 2019 external review report, former Ontario Deputy Minister of Justice Murray Segal found that the Diab case had been handled ethically in a manner that was consistent with Canadian law. He noted, however, that he had been not tasked with reviewing Canadian extradition law and policy more broadly. And it is that qualification that makes your study of extradition reform so important. Because Hassan Diab was extradited because the obvious misgivings and unease of the presiding judge that this was a weak case and he was unlikely to be convicted in a fair trial didn't matter. Because he was extradited even though the extraditing state was clearly nowhere near ready to go to trial. Because he was held without going to trial for over 3 years, almost the entire time in solitary confinement, a clear violation of international human rights. Because exculpatory evidence was withheld and Canadian government lawyers appeared more intent on assisting the French government than upholding the rights of a Canadian citizen. Because a Canadian citizen can be extradited to France in such spurious circumstances as this, while French law does not allow any French citizen to ever be extradited to Canada. And because all of this happened, even though Dr. Diab was represented by some of the most experienced defense lawyers in the country. If that human rights travesty is consistent with Canadian extradition law, there is something woefully wrong with extradition law, and you are going to hear a tremendous proposal for reform from Professor Curry.
Thank you, Mr. Neve. And now we'll go to Professor Curry for 5 minutes.
No, I think it's going to be me, if that's okay.
That's the game plan.
We'll let you do whatever you want. You can go for 5 minutes, and then we'll go to Mr. Curry after.
Well, thank you very much for the opportunity to be here today. I'm going to comment on 3 areas of needed extradition law reform. My first area of focus concerns the need for greater transparency and government disclosure of extradition-related data. One lesson learned from the media coverage of several contentious extradition cases is that the public needs to more clearly understand the extradition process, the role of the courts and the role of the minister, and the timelines involved. In the Meng Wanzhou extradition, the Department of Justice did eventually publish an infographic, a fact sheet, and some statistical information. But more is needed. Extradition law and practice is not well understood widely. And if we are to improve extradition, we need the data held within government. I suspect that this data will show that extradition is often not the speedy, efficient process it is pitched as being. We need to understand why, and to do that, we need the disclosure of information. Now, there are statutes that require designated ministers to prepare an annual report to Parliament on the implementation of a treaty and the enforcement of an act. The Corruption of Foreign Public Officials Act provides an example. It requires the Ministers of Foreign Affairs, International Trade, and Justice to jointly prepare a report on the implementation of the Anti-Bribery Convention and on the enforcement of the related legislation. In my view, a similar reporting obligation is needed in the Extradition Act so as to require the regular public disclosure of how many extradition requests Canada receives, from which countries, and for what crimes. And this annual report to Parliament should provide some information on what evaluation was undertaken of the requests received, the reasons for any delay, and the end result. It would also be helpful to indicate whether the individual requested for extradition was a Canadian citizen or a permanent resident. I make this last point as the cases that have taken many, many years in the Canadian courts so often have involved the requested extradition of Canadian citizens. There's also a need for the required public disclosure of the assurances provided by a foreign country that are used to secure an individual's extradition. With Canadian jurisprudence supporting the use of diplomatic assurances to alleviate any potential human rights risks arising, there is a rule of law rationale for making these assurances publicly available. Secrecy does not build trust in the rule of law, and publicity would add strength to any assurance provided by a foreign state. My second area of concern, my secondary focus, concerns the siloed nature of extradition practice and its centralization within the Department of Justice. By its very nature, extradition involves and implicates both international law and international relations. And it's for this reason I submit that extradition needs the involvement of both the Minister of Foreign Affairs and the Minister of Justice. The Extradition Act imposes a consultation obligation with the Minister of Immigration, but no consultation for the Minister of Foreign Affairs, despite the expertise available to the Foreign Affairs Minister for the assessment of a foreign state's human rights record, the fairness of its trials, and the conditions of its prisons. A Foreign Affairs Ministry also has the capacity to undertake the post-surrender monitoring recommended by an Australian parliamentary committee. Foreign affairs considerations should also be addressed at an earlier stage in the process, upon receipt of an extradition request. Justice Canada could be obliged to work with Global Affairs Canada on the consideration of all possible grounds for refusal of an extradition request at the preliminary stage rather than many years later in controversial cases. Alternatively, the evaluation of an extradition request could be made the responsibility of the Attorney General of Canada as the Chief Law Officer without the political responsibilities of the job of Justice Minister. My third area of reform is to reconsider the role of the extradition judge. Since extradition involves the loss of an individual's fundamental right to liberty, a rational basis exists for a more robust role to be accorded to the extradition judge. Indeed, in Victorian times, it was the role of the judge to consider whether extradition in the circumstances was unjust or oppressive. Today, Canadian extradition law directs that the Justice Minister make that call. Enabling a more robust role for the extradition judge would allow an individual's circumstances, the values of the Canadian legal system, and the human rights record of the requesting country to be considered directly and openly by a court. And on this note, I cede the floor to my colleague, Professor Robert Curry.
Over to you, Mr. Curry.
Thank you, Mr. Chairman. I hope I will have been worth waiting for. I'm honored to be invited to address this committee, and of course, I'd be very pleased to answer any questions that members have after my opening remarks. From the beginning, concerns were raised about the legal processes that were put in place under the Extradition Act, and specifically about the fairness of those procedures. The Supreme Court of Canada itself raised concerns in its 2006 decision in United States and Ferris, and put in place legal tests which were meant to ensure fairness. However, concerns remained, most poignantly demonstrated by Dr. Diab's case, as you've heard. In 2018, I had the honor of chairing a colloquium hosted by the McEachern Institute at Dalhousie University in Halifax on the topic of reforming Canada's extradition laws, policies, and practices. The colloquium was attended by people from across Canada who had expertise in extradition, international law, constitutional and criminal law and policy, and human rights. It included Professor Harrington and Mr. Neve, who are appearing here today. We produced a draft document that highlighted problems with extradition in Canada and proposed solutions, on which we received further input during a subsequent meeting hosted by Professor John Packer at the University of Ottawa. The end result was a document entitled Changing Canada's Extradition Laws, the Halifax Colloquium's Proposals for Law Reform, which I will refer to as the Halifax Proposals. It was published in 2021, and it is in materials which were circulated to you in advance of this hearing today. The document is 20 pages in length and covers a lot of ground, and I wouldn't be able to review it in detail for you. What I want to flag, however, for the committee is that the Halifax proposals are a serious and detailed plan for reform of Canada's extradition regime, formulated by people whose motivation is to improve the way these laws work and to protect the fundamental rights of Canadians. I and the other authors of the report sincerely hope that it can be a helpful part of meaningful parliamentary scrutiny into this issue, as begun by this committee in these hearings. And the idea is not that tinkering is required, but rather that a broad inquiry be made. At the heart of it is the proposition that Canada's laws, policies, and practices around extradition need to be scrutinized and reformed in accordance with three general principles. First, fundamental fairness. Second, transparency. And third, a rebalancing of roles. And by a rebalancing of roles, I mean the roles of the court and the government need to be rebalanced, and also a rebalancing of charter protections and administrative efficiency. I want to emphasize that while much of the reform agenda that we propose would involve amendments to the Extradition Act, the ambit is much wider than that. The Halifax proposals dig into pretty much the entire scope of extradition matters in which Canada plays a part. You've heard a selection of proposals that are included within the report and very much resonant of it from Professor Harrington, who was, of course, one of the attendees of the Halifax Colloquium. The Halifax proposals, though, look at the court procedures for the extradition hearings that take place here in Canada, as well as the process by which the Minister of Justice makes the final decision on extraditing in each case. However, it also makes recommendations on the international aspects of extradition, including Canada's practices in signing and administering treaties with other countries, Canada's role in ensuring fair treatment of individuals once they are extradited, and how the entire process needs to adhere to Canada's international human rights law obligations. It further looks at the role of the International Assistance Group and makes suggestions for how that office could play its role differently and how it could be restructured to facilitate that different role. I would conclude by suggesting that the world of extradition has traditionally been quite murky and below the public's radar, and troubling problems have been allowed to grow. The more Canadians have heard about cases like Dr. Diab's, the more disturbed they have become. This committee's inquiry represents a historic opportunity for Canadians to have input into a process that affects the rights of Canadians and others, and to ensure it's administered in a way that is fair and that comports with the principles of fundamental justice. Thank you.
Thank you. I want to thank all three of you. We'll begin our first round of questions. I'm just going to, for the interest of time, going to do 5-minute rounds and then 4-minute and then 2-minute, just so we, since we had started late, so we can be back on track. So beginning by Mr. Brock for 5 minutes.
Thank you, Chair, and I'd like to thank all the witnesses for your attendance and your participation in this study. Turning matters over to you, Professor Curry. With respect to the Halifax conference, were any members of the federal government in attendance?
They were not. No, this was, I guess you'd call a gathering of like-minded people who had previously expressed an interest in extradition reform. I don't think it was a secret. It was a publicly known about meeting, but no, there were no attendees of the crowd.
Following the conference and prior to the release of the recommendations in 2021, were there any consultations with any members of the federal government with respect to the details of those proposals?
Not prior to its publication, no.
Okay. Following publication, can you elaborate on what discussions you've had with the federal government?
We sent a copy of the report to the Prime Minister, and that report was copied to a number of ministers, certainly the Minister of Foreign Affairs, the Minister of Justice, and I can't bring the rest to mind, but there were several. Certainly, I think a number of us have had conversations with interested parties, certainly with politicians, I think federally and provincially. I'm certainly one who talks about extradition to anybody who will listen.
Did any thank you for that. Did any member of the federal government express a willingness to advance any of these proposals for improving the Extradition Act?
Advance them in what sense, sir?
In terms of accepting the recommendations and making suggestions to the department?
No, we certainly, the Minister of Justice was aware, and it was really an awareness-raising exercise. So any conversations that we had, to the best of my recollection, were along the lines of, here is a proposal we think law reform is called for.
Okay.
And the response was always, thank you very much.
All right. In an ideal situation, the government may or may not move forward with all of your recommendations, or this committee itself may ultimately produce a study that makes those recommendations on your behalf. Failing that, if you had to identify, say, your top 3 proposals that would significantly alter the landscape of the existing Extradition Act, bearing in mind the principles that you've touched upon and elaborated upon, and also on the issue of charter compliance, what would you suggest would be those top 3 proposals that this committee and this government should seriously look at?
Sure. I think changes to the committal process is the number 1 priority. That is really where Dr. Diab's case rests in terms of the demonstrable problems. And I'll highlight that, I guess, as part number 1. There are a number of changes that could be made. Certainly, any exculpatory evidence in the hands of either the Canadian Crown or the foreign state should be disclosed to the defense. We certainly propose that the presumption of reliability around the record of the case that's sent by the foreign state is removed. So there's a package, I guess you'd say, of issues there. Second, a number of the bases for refusal in the Act are allocated to the Minister of Justice. So the Minister is empowered to refuse on certain grounds, such as if the person will face double jeopardy or will face undue oppression. Some of those questions are really inherently legal questions, and we think not necessarily appropriately allocated to the minister who's acting in an explicitly political capacity as well as a legal capacity. So I guess that would be number 2. Number 3 would be a look at restructuring the International Assistance Group and dividing up the functions in terms of which staff, which lawyers are allocated to fight the case on behalf of the requesting state in our adversarial system. There's nothing inappropriate about doing that, but that branch of the office should be separate from the branch wherein the minister makes the surrender decision, so that it's not sort of all emerging from a black box. I would say those would be my top 3.
Thank you. I have 10 seconds left. That's fine. Chair, thank you.
Thank you, Mr. Brock. We'll now go to Ms. Lena Metleg-Diab for 5 minutes.
Much, Mr. Chair, and welcome to all our witnesses. And I want to say special welcome to Professor Curry, who is a constituent of mine. Although I've not spoken to him with regards to his testimony today, I did receive a message that he was appearing today. So let me just thank you and all the witnesses, but also all the work that you did in 2021 in the McEachern Institute to bring forth this very important, deficiency in some of the laws that we have. And I just want to, extradition is poorly understood by the general public in Canada. And I'm just going to go to, I know you've got, I've got your report here. There was 9. Let me ask you on your number 9, there's 12 points. Let me go to number 9, where you say there should be government parliamentary oversight of the activities of the IAG and the ability for meaningful public scrutiny of its activities and of the extradition process generally. This should involve appropriate transparency and publication of data and information. So I will ask, what do you think the proposed oversight should, where do you think it should live, and what can our committee and how should our committee play that role? And obviously you bringing this forward today and us bringing it here is we're starting to play a role. But what else can we do as parliamentarians?
And sorry, Ms. Diab, you're directing that question to me, are you?
Yes, Professor.
Sure, thank you. Professor Harrington covered off a couple of the answers to your question in her remarks. I wouldn't presume to tell Parliament how to do its job, but there are mechanisms that are already used. I think of the Security and Intelligence Review Committee, which oversees Canadian intelligence apparatus and is the receiver of annual reports on the kinds of activities engaged in by the particular departments, by the particular government entities. And to echo what Professor Harrington said, I think that's a good starting point. You know, that if the IAG were to be mandated in the Extradition Act to produce an annual report or a biannual report that provided statistics about the kinds of extradition requests that were made, the status of cases, consideration of them, naturally removing any privileged and confidential information. Like we all know that state-to-state communications are privileged, and certainly not suggesting that the entire thing needs to be blown wide open. I know that's a concern that the IAG has, but there's a distinction between the communications themselves and the fact of communications. So there's a lot of information that could be provided there. As well, I think this committee could certainly recommend to Parliament that the Extradition Act be amended to insert a requirement that data be published, again, on a website. And when I say data, I don't just mean statistics in this sense, but also internal policies and practices. And I'll draw the example of the government of the United Kingdom, which publishes its governmental policies around international cooperation techniques that it engages in. It sort of openly says, here are the things that the Home Secretary considers, and that kind of thing, lists of considerations. So that's the kind of thing I'm talking about, and that we're proposing in the Halifax proposals when we say transparency, publication of data and information. It's very helpful and democratically appropriate for Canadians to be able to access this information, again, subject to national security privilege and international relations.
Another quick question. I know the previous witnesses dealt with this, and so did the witnesses here. But the Extradition Act sets out a series of mandatory or discretionary grounds for refusing extradition. Which one of you three would be able to comment a little bit, for whatever time I have left, on what do you think would be appropriate grounds? And I know that's been commented on already, but I would like to have a bit more of that on the record.
I'll toss one in, and I'll simply say that I think one ground for refusal should be extreme disparity of sentencing between Canadian criminal law and the foreign states' criminal law. That has been a problem in numerous cases since the new act was brought in. But I'll leave it there and see if my colleagues have other proposals.
And I'll build on that and add into the mix any concerns that the extradition is going to lead to a violation of Canada's international human rights obligations.
Thank you. Thank you. We'll next go to Monsieur Fortin for 5 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Thank you to our witnesses. Mr. Curry, on the matter of, well, I understand that you do have a study from the Halifax Colloquium. It seems to be in great detail and will surely give us some good ideas. But I would like to hear you on how we should proceed at present. For example, when it comes to extradition, we do understand that there is the basic concern to the effect that the person, whether the person would reasonably likely to be found guilty of the crimes that are being held against them in the other country. It's not entirely clear to me. Right now, to your mind, would it be wise to hold a trial here in Canada of the individual possibly to be extradited to be sure that they're likely guilty, at least check that the data shows that it's likely they will be found guilty before we surrender them?
Thank you for the question. We do deal with that in the report. There are some cases in which that's an option, where Canada could prosecute, but also the foreign state could prosecute. It's not an option in every case, simply by way of the international law of jurisdiction and the way Canada conducts criminal prosecutions. But there are some cases, and specifically I'll mention those dealing with Canadian citizens, where if there's a cross-border aspect to the case, it may be that Canada has the option of prosecuting as well as the foreign state. And what we're proposing is not that it be an automatic prosecution in Canada in such cases, although it's not a bad idea. What we're proposing is that it would be a presumption, that it would be presumed that Canadians would be prosecuted here in Canada if that was a legal option, unless the government can show that it would be in the interest of justice for that person to be prosecuted in the foreign state. The government of the United Kingdom brought in a rule of this sort about a decade ago. It's called the Foreign Bar Rule, and it dealt with cases where that caused a lot of public disturbance in the UK, where people were threatened to be extradited to the US for activities that were mostly related to the UK. So we think that a rule that operated similarly could be brought in here, and it would fully flesh out the rights of Canadian citizens under Section 6 of the Charter of Rights and Freedoms.
Mais le cas échéant, ça veut dire qu'on tiendrait un procès.
But in such a case, we would be holding a trial here in Canada in a Canadian court to decide whether the person is guilty or not, although the person is held to be guilty under other legislation from another country, where the legislation is probably quite different from ours and where crimes are likely quite different than the ones we hold to be relevant. So, I'm just thinking of a number of situations that might lead to a great deal of complexity. Holding a trial in Canada with a court, a judge who does not know or knows little about the rules that would apply in the other country. Doesn't that just cause too many obstacles, that sort of approach?
I think I understand your question a little better. In principle, extradition is an important tool and a necessary tool in order for Canada to meet its international obligations and in order to ensure that people who break the law face justice. And there may be more situations in which it's appropriate to hold trials in Canada than is currently the case, but there are always going to be lots of cases where it's appropriate to extradite the individual as well. And in making the Halifax proposals, we were sensitive to the issue that the extradition hearing in Canada is not a substitute for a trial in the foreign country. So we fully anticipate there will always be extradition. There will always be people sent for trial in foreign countries. What we'd like to see is a fairer way of making the determinations about whether or not to extradite, certainly. And yes, that may involve more consideration of what the foreign state's criminal law system looks like. But that evidence is available out there, and it's available to be put before the court. So when you combine that with closer attention by the government to the state of affairs in the foreign state, both generally and with respect to particular cases, I think we could get an extradition process that works just as well, just as effectively and smoothly, but works in a more fair manner and prevents miscarriages of justice such as is happening to Dr. Diab.
Merci, Monsieur Curry.
Thank you, Mr.
Thank you, Mr. Curry.
For Mr. Garrison for 5 minutes.
Thank you very much, Mr. Chair. And I want to thank the witnesses not only for their testimony today, but each of them I know has been a powerful advocate in extradition cases in other situations, and also for bringing together the Halifax Colloquium, which has presented this committee with a very comprehensive and a very persuasive, I must say, report about the need for action. So my sincere thanks to the witnesses today. I want to ask a couple of specific things. One of those is about the 2S LGBTQI plus community, and in particular, the possible fate of transgender Canadians who might be facing extradition processes. My understanding is that there's no requirement in the current extradition law that the safety of those persons be considered in a surrender decision. I wonder if any of the three might be able to comment on that.
Go ahead. Go ahead, Joanna.
I'm sorry, Alex, I'm not there. So apologies. Yes, I can comment to say that I think this is where we feel that there is such a a reason for a strong human rights approach to extradition. So all sorts of human rights bases need to be considered with respect to a surrender decision. There is a past example in Canada of the Hurley case where the Minister of Foreign Affairs and the Minister of Justice did actually discuss what conditions should be placed on the surrender to a country where there was a concern of systemic discrimination against in that case, it was a gay man. And so I think the continued use of conditional extradition, which we are seeing more often, does require these consideration of, it's not just a yes or no, shall we surrender, but it's surrender on conditions to address the risk to the individual. So there is some past practice on that. Of course, if the case was of the concern in the other country was of such a high risk, then I think there's a situation where conditions won't address that. And that's an example where one should refuse extradition. Over to you, Alex.
I build on that by saying I think your concern is well placed, and I think as Professor Harrington's saying, it's reflective of a broader weakness about ensuring that there's strong human rights protections and safeguards. And I think what you're highlighting, the concern about how transgender individuals would be faced in an extradition context, is a very serious and very real example of where those concerns could arise. And we do need something more reliable. We do need to see, for instance, the whole range of Canada's international human rights obligations enshrined in the Extradition Act. And as the Halifax proposals suggest, perhaps shifting the responsibility for making those decisions out of the minister's hands and have that be part of the judicial process where we can have more assurance about the right decisions being made.
And that was really my second question. The report talks about shifting some things from the surrender decision to the committal process. And just so I understand what we're really saying, if we do that, that would be giving more responsibility to the extradition judge to make decisions on things which are essentially legal or human rights considerations, and leaving, if you made that transfer, the minister with more solely political considerations and perhaps follow-up considerations. Alex, maybe.
I think that's exactly right, that international human rights concerns need to be taken very seriously, not to be just part of a political discretionary process, which is why we feel those need to be with the judge. But Professor Curry may want to build on that as well.
That would be the heart of my comment as well. Human rights questions, to my mind, are not political questions. They're legal questions because rights are legally cognizable under law. They're meant to be affirmed and recognized and protected under Canadian law and under international law. Canada has obligations in both those regards. So fundamentally, human rights-oriented issues, and we're really talking about criminal process type issues, such as incarceration, right? Such as facing double jeopardy and so on. These are fundamentally legal questions that should be answered by the courts, who are uniquely empowered and able to do so. And frankly, in our adversarial decision-making system, both the parties and the individual sought on their counsel and the government is able to put forward evidence upon which those decisions can be based. So I think the courts are just a better place for many of those questions.
Cut me off there. Thank you.
I want to thank all the witnesses. Unfortunately, we're not going to get another round, but I want to thank you for your time and thank you once again for coming back despite our technical difficulties last time. Your testimony today has been very informative, and I look forward to reading some of your submissions as well. So thank you, and I want to say thank you to the witnesses. We just have a little bit of community business that we'll go through right after. So once again, thank you. As to committee business, I just want to remind everyone that witnesses list for our next study on Canada's bail system should be given by Friday end of day at the latest. If you can submit your lists, every party. And last, you've been sent the draft budget for our request for travel. It's almost identical to the last one. I think barring a few dollars, I think that might be different due to timing. So we have a timeline, deadline to resubmit, which I believe is tomorrow, and I could see Mr. Garrison's extreme pleasure with the study, so we'll make that noted. I'm kidding, we know you did.
Well, seriously, I'd like it noted that I do oppose the
Yes.
expenditure.
Duly noted. So if we can, by a nod of heads, are we okay with this, resubmitting this for the next cycle? Yes, I see Mr. Moore, okay, Mr. Sangari, Mr. Fortin, and now for Mr. Garrison. So thank you. Anything else, Mr. Clerk? No, we're good. We'll see you the next day. We now adjourn.